Welcome to Legal Listening, where audio obiter is our thing. We're Carly and Zach, and we're so glad you're here with us today. Okay, so today on the podcast, we have Smith and Jones, which I first learned in evidence law, but I think I also learned it in legal profession because it concerns privilege. It's a privilege case, which, as you well know, often overlaps between, evidence and legal profession. They sort of mix all together as privilege tends to be a legal ethical issue.
Yeah, I don't remember if I learned it in evidence, but that's not saying I didn't. But I definitely remember covering it in legal profession because and you're right, it does cross that threshold of, ethics and evidence often kind of intermingle because often persons in positions who will have the privilege will have sometimes evidence with respect to their clients. And it's what do you do with that information? When can you disclose it? When should it be disclosed? Is really the question in this case is when should evidence be disclosed to the public? And by the public, I mean the court.
Yes, and this is an example. It sort of sets out our legal test for the public safety exception to privilege. So privilege is obviously very sacred, very important, but this sort of sets out when can this privilege be broken because there is a threat to public safety. The case itself is very interesting. It involves a doctor retained for the purposes of, a criminal proceeding, and information comes to light to this doctor that the person he is dealing with, he thinks is actually a threat to public safety. So the question is, can he release this information or can he not? Because it's in the context of a proceeding. And it's very interesting how the court goes through and, there are limits. Although privilege is obviously a very sort of sacred concept, both in legal ethics and in evidence, there are limits to that privilege. And this, explains one of those limits. One of the limits is when it's a public safety concern.
Yeah. And I think talking about privilege broadly it's interesting how hard it is to conceptualize.
Yes.
Because you can understand it theoretically, and sure, you understand that privilege is a sacred thing and that you're not to disclose it. But the questions of that ethical boundary of when something crosses that gray line, how do you know what to do? And I think those are some of my favorite hypotheticals from law school have always been when can you divulge this information respecting to privilege? And then it follows up with what kind of privilege is there? Because we know there's multiple types.
Yes.
But just figuring out how they kind of conform to each case and when things can be disclosed and when things can be protected I don't think it's necessarily something you ever actually master. I think it's kind of takes a minute to learn, a lifelong to master kind of problem.
Oh, definitely. And, as obviously keeps coming up in every case we do that deals with legal ethics, this stuff can be very messy. I don't think the court is ever under the impression that these things are easy or necessarily intuitive for counsel. It's the type of thing that, you look to your mentors, you look to other people in practice, you look to people who've been practicing much longer than you, and you sort of try to figure it out to the best of your ability given the circumstances. It is a world of gray, a lot of these disclosure and privilege issues. And that's something that, Smith and Jones makes clear. This is definitely sort of an extreme example of public safety. And the court says, something similar. It has to be an actual imminent threat to public safety. It can't sort of just be, something that may happen, may or may not happen. But it's not easy. And I think the court definitely recognizes that in the decision. No one is saying that these are sort of super simple snap judgments that you can just make on the fly. They definitely take thought and time and looking into the context of what is happening.
Yeah, they're always these amorphous, very difficult things to pull apart and understand. And I think that's what makes them so great, though, to read and engage with, because I'm sure at some point when we start practicing and once we're called to the bar, these are problems that we're going to face. And the more knowledge that we have of having read these cases, the better we'll be prepared when we come into our own issues with respect to privilege.
Definitely. So we hope you enjoy, learn a little bit about the public interest exemption to privilege, and have fun listening to Smith and Jones. Smith and Jones. The dissenting reasons of Chief Justice Lemaire and Justices Major and Binney were delivered by Justice Major. Part 1. Introduction. I agree with Justice Corey's summation of the facts giving rise to this appeal and with his conclusion that the confidentiality of the solicitor-client privilege must, in exceptional circumstances of public safety, yield to the public good. The point of departure arises in the restriction each of us places on the scope of disclosure. In my opinion, a limited exception which does not include conscriptive evidence against the accused would address the immediate concern for public safety in this appeal while respecting the importance of the privilege. I do not read Justice Corey's reasons as imposing that limitation. This approach will, in my view, foster a climate in which dangerous individuals are more likely to disclose their disorders, seeking treatment, and pose less danger to public health. Part 2. The principles underlying solicitor-client privilege. In Canada, everyone is entitled to retain legal counsel to defend and protect their interests. This right is particularly important in criminal proceedings. The rationale for protection of the solicitor-client relationship was clearly stated by Chief Justice Jacket and Re Shell Canada Limited, and adopted by Justice Dixon for this court in Solowski and the Queen. If the confidences clients share with counsel were not protected by privilege, it seems apparent that accused persons would hesitate to confide in their legal advisors, who in turn could not adequately represent them. The starting point of Canadian justice is that no one, no matter how horrible the alleged offense, be denied a full defense, nor will they be prejudiced by retaining counsel and freely discussing the case with him or her. In the criminal context, principles embodied in the rules of privilege have gained constitutional protection by virtue of the enshrinement of the right to full answer and defense, the right to counsel, the right against self-incrimination, and the presumption of innocence in Sections 7, 10b, 11c, and 11d of the Canadian Charter of Rights and Freedoms. Each of these rights supports the extension of privilege to communications between clients and experts retained by their counsel for the purpose of preparing a defense. Together, they demonstrate the reasons for denying any use of solicitor-client communications against an accused in any legal proceeding. To deny the protection of solicitor-client privilege to the confidential communications of the accused, to those intimately involved in the preparation of his defense would frustrate these rights. For these reasons, the communications between an accused and his counsel, made in furtherance of his or her defense, are accorded the highest level of protection and confidentiality. Part 3. Extension of solicitor-client privilege to experts. In this case, the privilege is claimed not for the client's conversations with his lawyer, but those with the psychiatrist, whom his lawyer retained as an expert. Tradition and case law support the extension of this privilege to include communications, by conversation or otherwise, between the accused and the expert in the same way as the traditional solicitor-client relationship. Courts in Canada, Australia, the United Kingdom, and the United States have all concluded that client communications with third-party experts retained by counsel for the purpose of preparing their defense are protected by solicitor-client privilege. In Perron, the Crown was permitted to call and examine a psychiatrist who was retained by the defense but not called as a witness. The Quebec Court of Appeal held that the substance of the accused's communications with the psychiatrist were privileged and therefore inadmissible. The court adopted the opinion set out in City and County of San Francisco and Superior Court of the Supreme Court of California, who held that, quote, the privilege of confidence would be a vain one unless its exercise could be thus delegated. A communication, then, by any form of agency employed or set in motion by the client is within the privilege, end quote. Thus, when communication by a client to his attorney regarding his physical or mental condition requires the assistance of a physician to interpret the client condition to the attorney, the client may submit to an examination by the physician without fear that the latter will be compelled to reveal the information disclosed. The court concluded that communications between an accused and a psychiatrist come within the scope of the solicitor-client relationship and create the solicitor-client privilege. a privilege that goes to the heart of the ability of an accused to seek counsel and present a full answer and defense to the charges proffered against him. The Quebec Court of Appeal concluded in Perron, quote, "When counsel requires the services of an expert in order to help him better prepare his defense, he acts within the scope of his mandate. It is the interest of his client which compels counsel to confer on a specialist the charge of evaluating the case, and it follows that the accused must be able to undergo the evaluation in the same climate of confidence and in complete confidentiality as if he were communicating with counsel," end quote. The reasoning is persuasive and confirms that conversations with defense experts, such as psychiatrists, fall within the solicitor-client privilege and attract permanent and substantive privilege. Part 4. Is the substance of the psychiatrist's opinion privileged? The respondent asserts that even if Mr. Jones's communications are privileged, Dr. Smith's opinion based on those communications is not privileged, on the basis of the long-established maxim that there is no property in a witness. In the present case, the entire factual basis from which the witness's knowledge and opinion of the accused stem is the oral history provided by the accused. These communications and opinions arising from them are privileged, subject to the public safety exception. In Ward, the New South Wales Court of Criminal Appeal held the psychiatrist's evidence to be beyond the reach of the Crown. Quote, "The first substantial question to be considered is whether Dr. Barclay was retained by the appellant for the purpose of forming an opinion, as a psychiatrist, as to the appellant's mental condition, so that that opinion might, if the appellant desired, be used for the purpose of the forthcoming trial of the appellant. If he was so retained, then what the appellant had said to him was the subject of legal professional privilege, and unless the accused waived the privilege, Dr. Barclay's account of what he had been told by the appellant when interviewed and the opinion which he formed from that account could not be put before the jury," end quote. The judgment of Lord Blackburn in Lyle and Kennedy, cited with approval by Jacket in Susan Hosiery Limited and Minister of National Review, provides additional support for this conclusion. Quote, "It seems to me the plain reason and sense of the thing is that as soon as you say that the particular premises are privileged and protected, it follows that the mere opinion and belief of the party from those premises should be privileged and protected also. When the interrogatory is simply, what is the belief which you have formed from reading that brief, i.e. the privileged information, it seems to me to follow that you cannot ask that question," end quote. In Thorson and Jones, the client identified himself in strict confidence to his solicitor as the driver responsible for an unsolved hit and run. The court held that the client's identity constituted privileged information and was not to be revealed. Part 5. Purpose and application of the public safety exemption. I agree with Justice Corey that the standard of a clear, serious, and imminent danger is the appropriate test for disclosure of privileged communications. There are compelling public policy reasons for limiting disclosure to cases of clear and imminent danger. The record confirms that Mr. Jones only disclosed his secret plans because his lawyer had properly advised him that anything he said to Dr. Smith would be confidential. If Justice Corey is correct in holding that, in cases where the necessity test is met, the privilege is overridden to the extent of allowing disclosure of self-incriminating evidence, the result might endanger the public more than the public safety exemption would protect them. If defense counsel cannot freely refer clients, particularly dangerous ones, to medical or other experts without running a serious risk of the privilege being set aside, their response will be not to refer clients until after the trial, if at all. This could result in dangerous people remaining free on bail for long periods of time, undiagnosed and untreated, presenting a danger to society. The chilling effect of completely breaching the privilege would have the undesired effect of discouraging those individuals in need of treatment for serious and dangerous conditions from consulting professional help. In this case, the interests of the appellant, and more importantly, the interests of society, would be better served by his obtaining treatment. This court has recognized that mental health, including those suffering from potentially dangerous illnesses, is an important public good. Although the appellant did not go to Dr. Smith to seek treatment, it is obvious that he is more likely to get treatment when his condition is diagnosed than someone who keeps the secret of their illness to themselves. It seems apparent that society will suffer by imposing a disincentive for patients and criminally accused persons to speak frankly with counsel and medical experts retained on their behalf. As appealing as it may be to ensure that Mr. Jones does not slip back into the community without treatment for his condition, completely lifting the privilege and allowing his confidential communications to his legal advisor to be used against him in the most detrimental ways will not promote public safety, only silence. For this doubtful gain, the court will have imposed a veil of secrecy between criminal accused and their counsel, which the solicitor-client privilege was developed to prevent. Sanctioning a breach of privilege too hastily erodes the workings of the system of law in exchange for an illusory gain in public safety. Part 6. Application to the facts. While I agree with Justice Corey that the danger in this case is sufficiently clear, serious, and imminent to justify some warning to the relevant authorities, I find that the balance between the public interest in safety and the proper administration of justice is best struck by a more limited disclosure than the broader abrogation of privilege he proposes. In particular, Justice Corey endorses the trial judge's limitation of Dr. Smith's affidavit to those portions which indicate an imminent risk of serious harm or death. In the result, conscriptive evidence such as the accused's confession can be disclosed. In my opinion, the danger posed by the accused can be adequately addressed by the expression of that opinion by Dr. Smith without disclosing the confession. Two principles should guide the analysis of the scope of this disclosure. First, the breach of privilege must be as narrow as possible. Disclosure is justified only when it can actually accomplish something in the public interest, such as preserving injury or death. As the authors of The Future Crime or Tort Exception to Communication Privileges observe, quote, "The American canons of professional ethics make it clear that the attorney is released from his duty to maintain confidence in order to prevent the act or protect those against whom it is threatened," end quote. Second, an accused's right to consult counsel without fear of having his words used against him at trial is vital to our conception of justice. See R&P MB per the Chief Justice at paragraph 577, quote, "Perhaps the single most important organizing principle in criminal law is the right of an accused not to be forced into assisting in his or her own prosecution," end quote. All of the information upon which the respondent formed his concern about future conduct of the accused emanated from the accused himself and would not generally have been available. Our jurisprudence does not allow the conscription of an accused's own words against him. The immediate concern for public safety in this case is to ensure that the appellant not harm anyone. The solicitor-client privilege is a fundamental common law right of Canadians. That right must be interpreted in light of the Charter, which provides for the right of an accused to counsel. Any time such a fundamental right is eroded, the principle of minimal impairment must be observed. This can be accompanied by a limited disclosure of the psychiatrist's opinion. Courts are obligated to craft the narrowest possible exception to privilege, which accomplishes this purpose. Accordingly, Dr. Smith should be permitted to warn the relevant authorities, i.e., the Attorney General and sentencing judge, that Mr. Jones poses a threat to prostitutes in the Vancouver area. However, Dr. Smith should only disclose his opinion and the fact that it is based on a consultation with Mr. Jones. Specifically, he should not disclose any communication from the accused relating to the circumstances of the offense, nor should he be permitted to reveal any of the personal information which the trial judge excluded from his original order for disclosure. I agree with Justice Corey that in rare cases where an individual poses an instant risk, such that even an ex parte application to the court is not possible, the person reviewing the otherwise privileged information may issue a timely warning to the police. Otherwise, the scope and timing of disclosures should be dealt with by courts on a case-by-case basis. The public interest in cases such as this is twofold and requires not only that the dangerous individual is prevented from harming anyone, but that they obtain treatment if needed. Appealing as it might be to force individuals in Mr. Jones's position into treatment through the criminal process, it is unlikely to happen. If there is a risk that conscriptive evidence from the mouth of the accused can be used against them, the defense bar is going to be reluctant to refer dangerous clients to the care of experts. Disclosure will be discouraged and treatment will not occur. As the facts of this case illustrate, Mr. Jones was only diagnosed and made aware of the possibility of treatment because he felt secure in confiding to Dr. Smith. If that confidence is undermined, then these individuals will not disclose the danger they pose, they will not be identified, and public safety will suffer. Part 7. Scope of this decision. Justice Corey relies on American jurisprudence regarding the private law duty of physicians to warn potential victims of their dangerous patients. With respect, I think these cases are of limited usefulness, as they do not engage any of the legal and constitutional principles which underlie solicitor-client privilege. In the absence of that issue, in this case, I will not comment on the existence or scope of the duty to warn in private doctor-client relationships. This decision relates only to a limited exception to the solicitor-client privilege created by these facts and does not extinguish that privilege. It pertains only to the prevention of imminent perils and the ability of legal and medical professionals to warn the police and potential victims of clear, serious, and pressing dangers in the manner outlined. It follows that nothing in this decision is intended to decide whether any of the privileged communications made between Mr. Jones and Dr. Smith are admissible at any judicial proceedings. Those are issues to be determined by the presiding judge as they arose. Part 8. Disposition. Accordingly, I would allow the appeal without costs, confirm the entirety of Mr. Jones's communications to Dr. Smith to be privileged, but permit Dr. Smith to give his opinion and diagnosis of the danger posed by Mr. Jones. The judgment of Justices Leray Dubé, Gonthier, Corey, McLaughlin, Iacobucci, and Bestarche was delivered by Justice Corey. The solicitor-client privilege permits a client to talk freely to his or her lawyer, secure in the knowledge that the words and documents which fall within the scope of the privilege will not be disclosed. It has long been recognized that this principle is of fundamental importance to the administration of justice, and to the extent it is feasible, it should be maintained. Yet when public safety is involved and death or serious bodily harm is imminent, the privilege should be set aside. This appeal must determine what circumstances and factors should be considered and weighed in determining whether solicitor-client privilege should be set aside in the interest of protecting the safety of the public. Part A. Factual background. Solicitor-client privilege is claimed for a doctor's report. Pending the resolution of that claim, the names of the parties involved have been replaced by pseudonyms. The appellant, James Jones, was charged with aggravated sexual assault of a prostitute. His counsel referred him to a psychiatrist, the respondent, John Smith, for a forensic psychiatric assessment. It was hoped that it would be of assistance in the preparation of the defense or with submissions on sentencing in the event of a guilty plea. His counsel advised Mr. Jones that the consultation was privileged in the same way a consultation with him would be. Dr. Smith interviewed Mr. Jones for 90 minutes on July 30th, 1997. His findings are contained in an affidavit he submitted to the judge of first instance. They set out the basis for his belief that Mr. Jones poses a continuing danger to the public. Dr. Smith reported that Mr. Jones described in considerable detail his plan for the crime to which he subsequently pled guilty. It involved deliberately choosing as a victim a small prostitute who could be readily overwhelmed. He planned to have sex with her and then to kidnap her. He took duct tape and rope with him, as well as a small blue ball that he tried to force into the woman's mouth. Because he planned to kill her after the sexual assault, he made no attempt to hide his identity. Mr. Jones planned to strangle the victim and to dispose of her body in the bush area near Hope, British Columbia. He was going to shoot the woman in the face before burying her to impede identification. He had arranged time off from work and had carefully prepared his basement apartment to facilitate his planned sexual assault and murder. He had told people he would be going away on vacation so that no one would visit him, and he had fixed deadbolts on all the doors so that Key alone would not open them. Mr. Jones told Dr. Smith that his first victim would be a, quote, trial run, end quote, to see if he could live with what he had done. If he could, he planned to seek out similar victims. He stated that, by the time he had kidnapped his first victim, he expected that he would be in so deep that he would have no choice but to carry out his plans. On July 30th, Dr. Smith telephoned Mr. Jones' counsel and informed him that in his opinion Mr. Jones was a dangerous individual who would, more likely than not, commit future offenses unless he received sufficient treatment. On September 24, 1997, Mr. Jones pled guilty to aggravated assault and the matter was put over for sentencing. Sometime after, November 19th, Dr. Smith phoned Mr. Jones's counsel to inquire about the proceedings. On learning that the judge would not be advised of his concerns, Dr. Smith indicated that he intended to seek legal advice and shortly thereafter commenced this action. The in-camera hearing took place in December 1997. Dr. Smith filed an affidavit describing his interview with Mr. Jones and his opinion based upon the interview. Mr. Jones filed an affidavit in response. On December 12, 1997, Justice Henderson ruled that the public safety exception to the law of solicitor-client privilege and doctor-patient confidentiality released Dr. Smith from his duties of confidentiality. He went on to rule that Dr. Smith was under a duty to disclose to the police and to the Crown both the statements made by Mr. Jones and his opinion based upon them. Justice Henderson ordered a stay of his order to allow for an appeal, and Mr. Jones promptly appealed the decision. The Court of Appeal allowed the appeal, but only to the extent that the mandatory order was changed to one permitting Dr. Smith to disclose the information to the Crown and police. The order was stayed to permit Mr. Jones to consider a further appeal. It also directed that pseudonyms be used, that proceedings be heard in camera, and that the file remain sealed pending further order. This order is discussed in greater detail below. The sentencing of Mr. Jones on the aggravated assault charge was adjourned pending the outcome of this appeal. Part 2. Analysis. Subpart A. The nature of the solicitor-client privilege. Both parties made their submissions on the basis that the psychiatrist's report was protected by solicitor-client privilege, and it should be considered on that basis. It is the highest privilege recognized by the courts. By necessary implication, if a public safety exception applies to solicitor-client privilege, it applies to all classifications of privileges and duties of confidentiality. It follows that, in these reasons, it is not necessary to consider any distinctions that may exist between a solicitor-client privilege and a litigation privilege. The solicitor-client privilege has long been regarded as fundamentally important to our judicial system. Well over a century ago, in Anderson and Bank of British Columbia, the importance of the rule was recognized. Quote, "The object and meaning of the rule is this, that as, by reason of the complexity and difficulty of our law, litigation can only be properly conducted by professional men, it is absolutely necessary that a man, in order to prosecute his rights or defend himself from an improper claim, should have recourse to the assistance of professional lawyers. To use a vulgar phrase, that he should be able to make a clean breast of it to the gentleman whom he consults with a view to the prosecution of his claim, or the substanting of his defense. That he should be able to place unrestricted and unbounded confidence in the professional agent, and that the communications he so makes to him should be kept secret, unless with his consent, for it is his privilege and not the privilege of the confidential agent, that he should be enabled properly to conduct his litigation." End quote. Clients seeking advice must be able to speak freely to their lawyers, secure in the knowledge that what they say will not be divulged without their consent. It cannot be forgotten that the privilege is that of the client, not the lawyer. The privilege is essential if sound legal advice is to be given in every field. It has a deep significance in almost every situation where legal advice is sought, and whether it be with regard to corporate and commercial transactions, to family relationships, to civil litigation, or to criminal changes. Family secrets, company secrets, personal foibles, and indiscretions all must on occasion be revealed to the lawyer by the client. Without this privilege, clients can never be candid and furnish all of the relevant information that must be provided to lawyers if they are to properly advise their clients. It is an element that is both integral and extremely important to the functioning of the legal system. It is because of the fundamental importance of the privilege that the onus properly rests upon those seeking to set aside the privilege to justify taking such a significant step. As Chief Justice Lemaire stated in The Queen and Grunke, quote, "The prima facie protection for solicitor-client communications is based on the fact that the relationship and the communications between solicitor and client are essential to the effective operation of the legal system. Such communications are inextricably linked with the very system which desires the disclosure of the communication." End quote. The solicitor-client privilege was originally simply a rule of evidence, protecting communications only to the extent that a solicitor could not be forced to testify. Yet now it has evolved into a substantive rule. As Justice Dixon, as he then was, wrote in Solosky and the Queen, quote, "Recent case law has taken the traditional doctrine of privilege and placed it on a new plane. Privilege is no longer regarded merely as a rule of evidence, which acts as a shield to prevent privileged materials from being tendered in evidence in a courtroom." End quote. Justice Lemaire, as he then was, expanded on this statement in Descoteaux and Mierzinski when he discussed the content of this substantive rule. Quote, "It is quite apparent that the court in Solosky applied a standard that has nothing to do with the rule of evidence, the privilege, since there was never any question of testimony before a tribunal or court. The court, in fact, in my view, applied a substantive rule without actually formulating it, and, consequently, recognized implicitly that the right to confidentiality, which had long ago given rise to a rule of evidence, had also since given rise to a substantive rule. It would, I think, be useful for us to formulate this substantive rule, as the judges formally did with the rules of evidence. It could, in my view, be stated as follows. 1. The confidentiality of the communications between solicitor and client may be raised in any circumstances where such communications are likely to be disclosed without the client's consent. 2. Unless the law provides otherwise, when and to the extent that the legitimate exercise of a right would interfere with another person's right to have communications with his lawyer kept confidential, the resulting conflict should be resolved in favor of protecting the confidentiality. 3. When the law gives someone the authority to do something which, in the circumstances of the case, might interfere with the confidentiality, the decision to do so and the choice of means of exercising that authority should be determined with a view to not interfering with it except to the extent absolutely necessary in order to achieve the ends sought by the enabling legislation. 4. Acts providing otherwise in situations under paragraph 2 and enabling legislation referred to in paragraph 3 must not be interpreted restrictively." End quote. As the British Columbia Court of Appeal observed, the solicitor-client privilege is the privilege, quote, "which the law has been most zealous to protect and most reluctant to water down by exceptions." End quote. Quite simply, it is a principle of fundamental importance to the administration of justice. Subpart B. Limitations on solicitor-client privilege. Just as no right is absolute, so too the privilege, even that between solicitor and client, is subject to clearly defined exceptions. The decision to exclude evidence that would be both relevant and of substantial probative value because it is protected by solicitor-client privilege represents a policy decision. It is based upon the importance to our legal system in general of the solicitor-client privilege. In certain circumstances, however, other societal values must prevail. Innocence of the accused. One exception to solicitor-client privilege was set out in the Queen and Dunbar and Logan. Appeal Justice Martin, speaking for the court, ruled that solicitor-client privilege must yield to the right of accused persons to fully defend themselves. He wrote, quote, "No rule of policy requires the continued existence of the privilege in criminal cases where the person claiming the privilege no longer has any interest to protect, and when maintaining the privilege might screen from the jury information which would assist the accused," end quote. The House of Lords recently considered this issue in the Queen and Derby Magistrates Court. It held that solicitor-client privilege was absolute and permanent. It could not be set aside, even when to do so would allow an accused to present a full answer in defense to a criminal charge. With great respect, I prefer the reasoning of Appeal Justice Martin. Despite the strength and importance of the privilege, it remains subject to certain well-defined and limited exceptions. These exceptions are not foreclosed and may be expanded in the future, for example, to protect national security. However, the question of further exceptions need not to be considered in these reasons. It is significant and worthy of observation that Dunbar and Logan was cited with approval by this court in the Queen and Seaboyer, and in ALL and BA. At paragraph 69 of ALL and BA, quote, "When the enforcement of a privilege means that the accused will be limited as to his or her right to make full answer in defense to criminal accusations, this court has strongly tended to favor disclosure. Even the solicitor-client privilege, which has been elevated to a fundamental civil and legal right, will be overridden to allow the accused to make full answer and defense to criminal charges," end quote. Criminal communications. A second exception to solicitor-client privilege was set out in Descoteaux and Mierzwinski. Justice Lemaire for the court held that communications that are criminal in themselves, in this case a fraudulent legal aid application, or that are intended to obtain legal advice to facilitate criminal activities, are not privileged. At paragraph 893, this appears, quote, "There are certain exceptions to the principle of the confidentiality of solicitor-client communications, however. Thus, communications that are in themselves criminal or that are made with a view to obtaining legal advice to facilitate the commission of a crime will not be privileged inter alia," end quote. The public safety exception. In Solosky, an inmate in a federal penitentiary asked this court to make a declaration that all properly identified correspondence between solicitors and clients would be forwarded to their destinations without being opened. The inmate's privilege was in conflict with the Penitentiary Act, Royal Statute of Canada 1970, and with Regulation 2.18 of the Penitentiary Service Regulations, which allowed the institution's director to censor any correspondence to the extent the censor considered necessary. In his decision, Justice Dixon ruled that the inmate's privilege must yield when the safety of the members of the institution is at risk. In his reasons, he implicitly limited the solicitor-client privilege. He wrote, quote, "The result, as I see it, is that the court is placed in the position of having to balance the public interest in maintaining the safety and security of a penal institution, its staff, and its inmates, with the interest represented by insulating the solicitor-client relationship. Even giving full recognition to the right of an inmate to correspond freely with his legal advisor and the need for minimum derogation therefrom, the scale must ultimately come down in favor of the public interest. In certain circumstances, therefore, when the safety of the public is at risk, the solicitor-client privilege may be set aside," end quote. Courts in other jurisdictions have considered the issue of public safety exceptions to privilege, particularly in doctor-patient relationships. Obviously, these cases do not deal with solicitor-client privilege. However, they do support the position that other privileges are subject to the public interest. Moreover, they assist in determining the approach that should be taken to the consideration of the issue of privilege. Further, these cases are useful in exploring certain issues that arise in this case. For example, how the victim class can be identified and how specific the potential victim or class must be. I would emphasize that these cases are not being examined with a view to establish a tort duty on doctors to disclose confidential information when a public safety concern arises. That issue is not before the court and must not be decided without a factual background and the benefit of argument. American decisions. In Tarasoff and Regents of the University of California, the Supreme Court of California considered whether psychologists and psychiatrists have a duty to warn a potential victim when they were or should have been aware that a patient presented a serious danger to an identifiable person. In that case, a patient under the care of the respondents, a psychologist and 2 psychiatrists employed by the University of California, confessed to his psychologist his intention to kill a young girl who was readily identifiable from his description. The psychologist contacted the police, who questioned and briefly detained the patient, but released him because he appeared rational. 2 months later, the patient killed the girl. Her parents brought an action against the therapists for failure to warn them of the danger to their daughter. Justice Tobrenner of the California Supreme Court wrote, quote, "When a therapist determines, or pursuant to the standards of his profession should determine, that his patient presents a serious danger of violence to another, he incurs an obligation to use reasonable care to protect the intended victim against such a danger. The discharge of this duty may require the therapist to take one or more various steps depending on the nature of the case. Thus, it may call for him to warn the intended victim, or others likely to apprise the victim of the danger, to notify the police, or to take whatever other steps are reasonably necessary under the circumstances." End quote. He went on to observe that the public interest in maintaining access to mental health treatment had to be balanced against the public interest in safety. Quote, "We recognize the public interest in supporting effective treatment of mental illness and in protecting the rights of patients to privacy, and the consequent public importance of safeguarding the confidential character of psychotherapeutic communication. Against this interest, however, we must weigh the public interest in safety from violent assault. We conclude that the public policy favoring protection of the confidential character of patient-psychotherapist communications must yield to the extent to which disclosure is essential to avert danger to others. The protective privilege ends where the public peril begins." End quote. In Thompson, in County of Alameda, county officials were aware of the violent propensities of a juvenile delinquent in their care. These violent propensities were directed towards young children. The county released the juvenile delinquent from custody into the care of his mother. Within 24 hours, he had sexually assaulted and murdered the 5-year-old girl who lived next door. The parents of the victim sued the county for, inter alia, failing to warn them. The Supreme Court dismissed their suit. In reaching its decision, the majority of the court held that Tarasoff was distinguishable because the victim in Tarasoff, quote, "was the known and specifically foreseeable and identifiable victim of the patient's threats." Justice Richardson explained and distinguished the decision in Tarasoff in this way. Quote, "We made clear that the therapist has no general duty to warn of each threat. Only if he does in fact determine, or under applicable professional standards reasonably should have determined, that a patient poses a serious danger of violence to others, does he bear a duty to exercise reasonable care to protect the foreseeable victim of that danger." Unlike Johnson and State of California and Tarasoff, plaintiffs here have alleged neither that a direct or continuing relationship between them and the county existed through which the county placed the plaintiff's decedent in danger, nor that their decedent was a foreseeable or readily identifiable target of the juvenile offender's threats. The court thus explicitly limited the duty to warn to cases in which danger to a particular victim was foreseeable. Justice Richardson wrote, quote, "Bearing in mind the ever-present danger of parole violations, we nonetheless conclude that public entities and employees have no affirmative duty to warn of the release of an inmate with a violent history who has made non-specific threats of harm directed at non-specific victims." End quote. In California, the duty to warn was thus restricted to cases in which specific threats of harm were directed against specific victims. This position was reiterated in Brady and Hopper. James Brady and 2 others were suing Dr. John Hopper, John Hinckley's psychiatrist, in tort for the injuries they suffered during Hinckley's attempt to assassinate President Reagan.
The court dismissed their claim, finding that Hinckley had made no threats upon which a duty to warn could have been based. Justice Moore wrote, quote, "Nowhere in the complaint are there allegations that Hinckley made any threats regarding President Reagan or indeed that he ever threatened anyone," end quote. It was determined that the duty to warn did not arise until such time as both the threat and the possible victim could be identified. Something more than merely speculative risk of harm to unidentifiable persons was necessary. Quote, "Once the patient verbalizes his intentions and directs his threats to identifiable victims, then the possibility of harm to third persons becomes foreseeable, and the therapist has a duty to protect those third persons from the threatened harm," end quote. The reasons in Brady and Hopper made it clear that the duty to warn should not be interpreted in such a wide and encompassing manner that therapists would become responsible for all their patients' violent actions. Such a test would be unreasonable and upset the balance between public safety and the importance to society of cultivating confidential relationships. Justice Moore wrote, quote, "In my opinion, the specific threats to specific victims rule states a workable, reasonable, and fair boundary upon the sphere of a therapist's liability to third persons for the acts of their patients," end quote. There is much to commend these well-reasoned American decisions, yet they lead me to believe that two observations should be made. First, it will not always be necessary to identify a specific individual as the victim. Rather, it may be sufficient to engage the duty to warn if a class of victims, such as little girls under 5 living in a specific area, is clearly identified. Second, although Justice Moore speaks of the patient verbalizing his intentions, I believe it is more appropriate to speak of a person making known his or her intentions. While speech is perhaps the most common means of making intentions known, it is certainly not the only manner of indicating a clear intention. It could be accomplished soundlessly, yet with brutal clarity, by thrusting a knife through a photograph of the intended victim. United Kingdom decisions. The leading case in the United Kingdom on balancing the duty of confidentiality and the duty to disclose is W and Egdell. Although the facts differ somewhat from this case, enough similarities exist to make the reasoning set out in the two concurring judgments helpful to the considerations that must be given to the case at bar. In that case, W pled guilty to manslaughter after committing a series of killings. As a result of a finding of diminished responsibility, he was confined to a mental institution. 10 years later, he applied pursuant to the appropriate regulations for a conditional discharge or a transfer to a regional secure unit. To this end, through his solicitors, W consulted Dr. Egdell, a psychiatrist, who was to report on his mental state. His report did not support W's application for transfer. Rather, he expressed grave concerns regarding W's lack of remorse and his continuing interest in homemade bombs and fireworks. As a result, W withdrew his application. Shortly thereafter, Dr. Egdell telephoned the tribunal that was to review W's application to ask whether it had received a copy of his report. He learned that it had not, and that the application had been withdrawn. He telephoned W's solicitors for permission to forward his report to the assistant medical director of the hospital in which W was incarcerated and was refused. Nonetheless, Dr. Egdell forwarded his report to the hospital, which then forwarded it to the Home Office. Both of these copies were sent without W's permission or knowledge. By chance, several days later, W's file was due for a 3-year review under the Mental Health Act. It was then that his solicitors learned that Dr. Egdell's report had been forwarded to the hospital. W began proceedings seeking an injunction to prevent the Medical Health Review Tribunal from disclosing or considering Dr. Egdell's report, for the delivery of all copies of the report to him, and for damages for breach of the duty of confidence. In their concurring judgments, Sir Stephen Brown and Lord Justice Bingham affirmed the trial judge's ruling, dismissing W's suit. Lord Justice Bingham said, quote, "The law treats such duties of confidentiality not as absolute, but as liable to be overridden when there is held to be a stronger public interest in disclosure," end quote. both justices agreed with the trial judge that the threshold for disclosure was met. The harm that could result if W's mental illnesses were not adequately recognized and treated was serious, and the displacing of doctor-patient confidentiality was justified in light of the existing circumstances. The fact that W had already committed murder was obviously significant. Sir Stephen Brown wrote at paragraph 846, quote, "The balance of public interest clearly lay in the restricted disclosure of vital information to the director of the hospital and to the Secretary of State, who had the onerous duty of safeguarding public safety," end quote. In this case, the number and nature of killings by W must inevitably give rise to the gravest concern for the safety of the public. In the United Kingdom, the duty on a doctor not to disclose is never absolute. Further, the duty to disclose must be evaluated in the context of the existing circumstances and the specific facts presented. Subpart C, the public safety exception and solicitor-client privilege. The foregoing review makes it clear that even the fundamentally important right to confidentiality is not absolute in doctor-patient relationships, and it cannot be absolute in solicitor-client relationships. When the interest in the protection of the innocent accused and the safety of members of the public is engaged, the privilege will have to be balanced against these other compelling public needs. In rare circumstances, these public interests may be so compelling that the privilege must be displaced. Yet the right to privacy in a solicitor-client relationship is so fundamentally important that only a compelling public interest may justify setting aside solicitor-client privilege. Danger to public safety can, in appropriate circumstances, provide the requisite justification. It is significant that public safety expectations to solicitor-client privilege are recognized by all professional legal bodies within Canada. See, for example, Chapter 5, Section 12 of the British Columbia Professional Conduct Handbook. See as well the even broader Rule 4.11 of the Law Society of Upper Canada's Professional Conduct Handbook. Quite simply, society recognizes that safety of the public is of such an importance that in appropriate circumstances it will warrant setting aside solicitor-client privilege. What factors should be taken into consideration in determining whether that privilege should be displaced? 1. Determining whether public safety outweighs solicitor-client privilege. There are 3 factors to be considered. First, is there a clear risk to an identifiable person or group of persons? Second, is there a risk of serious bodily harm or death? Third, is the danger imminent? Clearly, if the risk is imminent, the danger is serious. These factors will often overlap and vary in their importance and significance. The weight to be attached to each will vary with the circumstances presented by each case, but they all must be considered. As well, each factor is composed of various aspects, and, like the factors themselves, these aspects may overlap, and the weight to be given to them will vary depending on the circumstances of each case. Yet as a general rule, if the privilege is to be set aside, the court must find that there is an imminent risk of serious bodily harm or death to an identifiable group or person. Clarity. What should be considered in determining if there is a clear risk to an identifiable group or person? It will be appropriate and relevant to consider the answers a particular case may provide to the following questions. Is there evidence of long-range planning? Has a method for effecting the specific attack been suggested? Is there a prior history of violence or threats of violence? Are the prior assaults or threats of violence similar to that which was planned? Is there a history of violence? Has the violence increased in severity? Is the violence directed to an identifiable person or group of persons? This is not an all-encompassing list. It is important to note, however, that as a general rule, a group or person must be ascertainable. The requisite specificity of that identification will vary depending on the other factors discussed here. The specific questions to be considered under this heading will vary with the particular circumstances of each case. Great significance might, in some situations, be given to the particularly clear identification of a particular individual or group of intended victims. Even if the group of intended victims is large, considerable significance can be given to the threat if identification of the group is clear and forceful. For example, a threat put forward with chilling detail to kill or seriously injure children 5 years of age and under would have to be given very careful consideration. In certain circumstances, it might be that a threat of death directed towards single women living in apartment buildings could, in combination with other factors, be sufficient in the particular circumstances to justify setting aside the privilege. At the same time, a general threat of death or violence directed to everyone in a city or community or anyone with whom the person may come into contact may be too vague to warrant setting aside the privilege. However, if the threatened harm to the members of the public was particularly compelling, extremely serious, and imminent, it might well be appropriate to lift the privilege. See in this regard Egdell. All the surrounding circumstances will have to be taken into consideration in every case. In sum, the threatened group may be large, but if it is clearly identifiable, then it is a factor, indeed an essential factor, that must be considered together with others in determining whether the solicitor-client privilege should be set aside. A test that requires that the class of victim be ascertainable allows the trial judge sufficient flexibility to determine whether the public safety exemption has been made out. Seriousness. The seriousness factor requires that the threat be such that the intended victim is in danger of being killed or suffering a serious bodily harm. Many persons involved in criminal justice proceedings will have committed prior crimes or may be planning to commit crimes in future. The disclosure of planned future crimes without an element of violence would be an insufficient reason to set aside solicitor-client privilege because of fears of public safety. For the public safety interest to be of sufficient importance to displace solicitor-client privilege, the threat must be to occasion serious bodily harm or death. It should be observed that serious psychological harm may constitute serious bodily harm, as this court held in the Queen and McCraw. Quote, so long as the psychological harm substantially interferes with the health or well-being of the complainant, it properly comes within the scope of the phrase serious bodily harm. There can be no doubt that psychological harm may often be more pervasive and permanent in its effect than any physical harm. End quote. Imminence. The risk of serious bodily harm or death must be imminent if solicitor-client communications are to be disclosed. That is, the risk itself must be serious, a serious risk of serious bodily harm. The nature of the threat must be such that it creates a sense of urgency. This sense of urgency may be applicable to some time in the future. Depending on the seriousness and clarity of the threat, it will not always be necessary to impose a particular time limit on the risk. It is sufficient if there is a clear and imminent threat of serious bodily harm to an identifiable group, and if this threat is made in such a manner that the sense of urgency is created. A statement made in a fleeting fit of anger will usually be insufficient to disturb the solicitor-client privilege. On the other hand, imminence as a factor may be satisfied if a person makes a clear threat to kill someone that he vows to carry out 3 years hence when he is released from prison. If that threat is made with such chilling intensity and graphic detail that a reasonable bystander would be convinced that the killing would be carried out, the threat could be considered to be imminent. Imminence, like the other two criteria, must be defined in the context of each situation. In summary, solicitor-client privilege should be only set aside in situations where the facts raise real concerns that an identifiable individual or group is in imminent danger of death or serious bodily harm. The facts must be carefully considered to determine whether the 3 factors of seriousness, clarity, and imminence indicate that the privilege cannot be maintained. Different weights will be given to each factor in any particular case. If after considering all appropriate factors it is determined that the threat to public safety outweighs the need to preserve solicitor-client privilege, then the privilege must be set aside. When it is, the disclosure should be limited so that it includes only the information necessary to protect public safety. See in that respect Descoteaux. Part 2. Extent of disclosure. The disclosure of the privileged communication should generally be limited as much as possible. the judge setting aside the solicitor-client privilege should strive to strictly limit disclosure to those aspects of the report or document which indicate that there is an imminent risk of serious bodily harm or death to an identifiable person or group. In undertaking this task, consideration should be given to those portions of the report which refer to the risk of serious harm to an identifiable group, and the risk is serious in that it involves a danger of death or serious bodily harm, and that the serious risk is imminent in the sense given to that word in paragraph 84 above. The requirement that the disclosure be limited must be emphasized. For example, if a report contained references to criminal behavior that did not have an imminent risk of serious bodily harm, but disclosed, for example, the commission of crimes of fraud, counterfeiting, or the sale of stolen goods, those references would necessarily be deleted. Part D. Application of the public safety exemption to solicitor-client privilege to the case at bar. 1. Clarity. Would a reasonable observer, given all the facts for which solicitor-client privilege is sought, consider the potential danger posed by Mr. Jones to be clear, serious, and imminent? The answer must, I think, be in the affirmative. According to Dr. Smith's affidavit, the plan described by Mr. Jones demonstrated a number of the factors that should be considered in determining the clarity of the potential danger. They are the clear identification of the victim group, the specificity of method, the evidence of planning, and the prior attempted or actual acts that mirror the potential act of threatened future harm. It is apparent that Mr. Jones had planned in considerable detail attacks on prostitutes on Vancouver's downtown east side. He had gathered materials together that he planned to use to achieve his ultimate goal of forcing a prostitute to become his sex slave before killing her. He had arranged for vacation time from his job and had modified his basement apartment to ensure that no one else could enter. Mr. Jones had proceeded so far as to take rope and duct tape with him and had planned to shoot the intended victim in the face to obliterate her identity. Perhaps most important, he had called the initial assault to which he pled guilty a trial run. These factors should be considered together with Dr. Smith's diagnosis of Mr. Jones, namely that he suffered a paraphiliac disorder with multiple paraphilias, in particular sexual sadism, personality disorder with mixed features, and some antisocial features and drug abuse difficulty. The original planning and prior attack on a prostitute emphasized the potential risk of serious bodily harm or death to prostitutes in the downtown east side of Vancouver. Although Mr. Jones attempted to explain his failure to seek treatment for fear of a longer sentence and the danger he would be exposed to in prison, this does not affect the gravity of the threatened attack on prostitutes. The combination of the factors referred to in the paragraph above meets the standard of clarity necessary to set aside solicitor-client privilege. The potential victim or group of victims is identifiable. Mr. Jones had already acted once in committing the crime for which he is waiting to be sentenced. It is clear that he intended to act again. The risk of serious bodily harm or death was readily apparent, and the group of victims was readily identifiable. The harm potentially caused was of the utmost gravity. Seriousness. The seriousness of potential harm, a sexually sadistic murder, is clearly sufficient. The fact that Mr. Jones has, after careful and detailed planning, already committed an assault upon a prostitute supports the finding that the potential harm caused would be extremely serious. Imminence. The most difficult issue to resolve is whether the risk of serious bodily harm can be termed imminent. Mr. Jones was arrested on September 17, 1996, for the assault he had committed 3 days earlier. He consulted Dr. Smith on July 30, 1997. Dr. Smith contacted Mr. Jones's counsel the following day to inform him that, in Dr. Smith's opinion, Mr. Jones was a dangerous individual. About 3 months later, some 14 months after Mr. Jones's arrest, Dr. Smith telephoned Mr. Jones's counsel again and learned that his, Dr. Smith's concern, would not be addressed in the sentencing hearing. He then began these legal proceedings. Mr. Jones has been in custody since December 15, 1997, pursuant to the order of Justice Henderson. Mr. Jones was thus at liberty from September 14, 1996 to December 15, 1997, a period of almost 15 months. During that time, he did not carry out his plan to attack and kill another prostitute. Moreover, Mr. Jones has not carried out a series of attacks over a period of time which would lead to the conclusion that another attack was imminent. He has been charged and convicted of only one incident. No evidence was adduced as to whether Dr. Smith considered that a future attack was imminent. It is noteworthy that, first, he waited over 3 months to contact Mr. Jones's counsel. Second, there is no evidence that he believed it was probable Mr. Jones would commit a serious attack in the near future. Yet it must be remembered that Dr. Smith did take it upon himself to call Mr. Jones's counsel regarding the sentencing hearing. Even more significantly, Dr. Smith undertook these proceedings so that his report and opinion might be considered in the sentencing of Mr. Jones. There are 2 important factors that indicate that the threat of serious bodily harm was indeed imminent. First, Mr. Jones admitted that he had breached his bail conditions by continuing to visit the downtown East Side where he knew prostitutes could be found. Second, common sense would indicate that after Mr. Jones was arrested and while he was awaiting sentence, he would have been acutely aware of the consequences of his actions. This is of particular significance in light of his fear of being attacked while he was in jail. Let us assume that the evidence as to imminence of the danger may not be as clear as might be desired. Nonetheless, there is some evidence of imminence. Furthermore, the other factors pertaining to clarity, the identifiable group of victims, and the chilling evidence of careful planning, when taken together, indicate that the solicitor-client privilege must be set aside for the protection of members of the public. The judge of first instance very properly limited disclosure of Dr. Smith's affidavit to those portions of it which indicated that there was an imminent risk of death or serious bodily harm to an identifiable group comprising prostitutes located in the downtown East Side of Vancouver. In light of these conclusions, the solicitor-client privilege attaching to Dr. Smith's report, to the extent provided by the order of Justice Henderson, must be set aside. Part E. Appropriate procedures to adopt. Dr. Smith chose to bring a legal action for a declaration that he was entitled to disclose the information he had in his possession in the interests of public safety. However, this is not the only manner in which experts may proceed. Although it is true that this procedure may protect the expert from legal consequences, there may not always be time for such an action. In whatever action is taken by the expert, care should be exercised that only that information which is necessary to alleviate the threat to public safety is revealed. It is not appropriate in these reasons to consider the precise steps an expert might take to prevent the harm to the public. It is sufficient to observe that it might be appropriate to notify the potential victim or the police or a Crown prosecutor, depending on the specifics of the circumstances. Part F. The lifting of the publication ban. Justice Henderson was concerned that because of the nature of these proceedings, the protection offered by solicitor-client privilege would be improperly and irretrievably lost by premature publication of the details of the case. As a result, he sealed the file. The British Columbia Court of Appeal continued the order for sealing the file. The same order was confirmed by this court. As well, publication of the contents of the file was prohibited. For this court to seal a file was a highly unusual procedure. It was required because if solicitor-client privilege did attach to Dr. Smith's report, it could never be made public. In other words, the file could only be unsealed and the documents made public if it was determined that solicitor-client privilege should not apply to the report because of the existence of the danger to the public. In this court, the entire affidavit of Dr. Smith was read and considered. I agree with the deletions referred to in the order made by Justice Henderson. Those references are either not relevant to the issue of dangerousness or have such a minimal probative value that they should not form part of the consideration of danger to the public. Nor should they form part of the released record. It is true that the proceedings of this court should be as open as possible, yet the exercised portions could never form part of the record. They would be inadmissible as evidence on the issue of danger to the public. The record will be unsealed, and the affidavit of Dr. Smith, as edited pursuant to the order of Justice Henderson, will be made public together with all the other material in the court's file. There may be situations where further consideration will have to be given to this issue. For example, where this court takes into account more of the privileged document in determining the issue of dangerousness than did the courts below, so that the entire document forms an integral part of the court's decision. More of the privileged document may need to be released. The question cannot, however, be resolved in this case. In the result, the file will be unsealed and the ban on the publication of the contents of the file removed, except for those parts of the affidavit of the doctor which do not fall within the public safety exemption. Subject to this discretion, the order of the British Columbia Court of Appeal is affirmed. I would add that a motion was brought that this appeal be heard in camera. This motion was denied at the outset of the hearing. Members of the press and public were present throughout, but were until now subject to the ban on publication. Part G. Costs. Dr. Smith seeks to recover his costs. He should not have them. This case raised the issue of when solicitor-client privilege can be set aside. It has been found that, because of the danger posed by Mr. Jones to the public, solicitor-client privilege, which Mr. Jones had every right to believe attached to Dr. Smith's report, was set aside. This case arises in the context of criminal proceedings, and the result may well affect the sentence imposed on Mr. Jones. It would be unfair and unjust in the circumstances to impose the burden of costs on Mr. Jones, and I would not do so. Part 3. Disposition. The file will be unsealed, and the ban on the publication of the contents of the file is removed, except for the parts of the affidavit of the doctor which do not fall within the public safety exemption. Subject to this direction of the order of the British Columbia Court of Appeal is affirmed, and this appeal is dismissed without costs.
Thanks for the listen, friend. I hope you're able to enjoy that case and learn something new from it. Legal Listening is founded by Zach Battiston and Carly Lyons. It is hosted by Zach Battiston, Carly Lyons, and you, our listeners. Executive produced by Zach Battiston, Carly Lyons, and Anthony Radomile. Audio engineering by Anthony Radomile. Graphic design by Julie Lundy. Check her out online at julielundyart.com. And music done by Matt Radomile at radandkel.com. At Legal Listening, we're always open to new ideas, suggestions, and of course, guest readers. Check us out on Twitter at Legal Listening or online at legallistening.com. Legal Listening, where audio obiter is our thing. We'll catch you in the next case. Bye now.